Thank you, Ed. I feel like I need to walk out and smoke and lights and stuff. Thank you for that very kind introduction. I wasn't clear whether or not you were going to be able to read my writing, so thank you for that. All right, so today, first of all, before we get going, I want to pass on a little bit of a thanks myself. Every year we do the Solicitors Conference, I am amazed at how 4 or 5 people can put together a conference with so many people. Of course, this year has been probably more challenging than any Solicitors Conference we've had ever. And I just want to say, I want to take first a moment to say thank you so much to Lisa and her team, Sarah Lee, Amy, Jennifer, Tina, and Andrea for pulling all this together and getting us together and able to have this conference despite all the challenges of social distancing and making this work through the cyber world. You guys do a great job, and thank you so much for the work that you've done, and thanks for bringing us here today. What I want to talk about today is something, and I know we just got through going over important Supreme Court decisions, but in my mind, one of the most, if not the most important Supreme Court decision that recently came out is the State versus Aaron Young. And this case is one that came from my circuit. It was a case that we tried a few years ago, and in fact, I talked to the Solicitors Conference about this 2 years ago, I think it was, 3 years ago, giving them some kind of idea about what was coming down the pipe, because this was something that I felt like was going to be important. I have 5 counties. The 14th Circuit is made up of Beaufort, Jasper, Allendale, Hampton, and Collison counties, and like all of you, I have gangs in every one of those counties. We have situations in which we have lots of clubs, late night hangout spots, in which basically the last call is brought about by a hail of gunfire. We have drive-by shootings. We have neighborhood on neighborhoods or gangs on gang shootings. And all of this, to be said, sometimes these gang members and these club participants shoot each other. Sometimes, though, they shoot innocent people as well. And the idea of how we tackle these type of problems throughout the state has been something that sort of has bothered me and concerned me for quite a while. In South Carolina, we do not have a gang statute. North Carolina has a gang statute. Georgia has a gang statute. And what gang statutes do, much like the Federal RICO Act, is they allow you to go after, not only for an arrest, but a prosecution, whole groups of people, everybody involved, instead of just 1 or 2. We've known since the very, probably the taking out of the Chicago mobs back in the 30s, that you can't go at it piecemeal. You can't just go in and grab one member of the gang or the mob and you prosecute them, you put them in prison. They are replaced in the hierarchy by the time they get through bond court. So in order to actually be effective, what the federal government came up with was the RICO Act, and this is what was then used in New York to come in and take down the gangs in New York. The concept is you go after the organization itself, you go after everyone involved, not just 1 or 2. What makes gang prosecution in South Carolina so difficult is that we don't have anything like that. And we don't have anything that, no matter how big or small the gang is, no matter how many people are involved. Generally speaking, we have spent a lot of time trying to determine when there is a shootout. If somebody shoots an innocent person, we spend all of our time trying to figure out who shot the fatal bullet. And of course, that's extremely difficult because, number one, nobody sees anything. Number 2, those that do see anything usually say something in the line of, I'll handle this myself. So we don't get a lot of good, clear testimony. Very rarely is the gun actually ever recovered in one of these situations. And if it does, it certainly doesn't trace back to anyone. So that's pretty much useless. So what we were looking at when we approached this case was trying to figure out a way to hold every shooter accountable for every bullet fired. Instead of going after just the person that we could prove was the trigger man of the fatal bullet, but what about all the other people involved in the shootout? Whether that's 2 people, 5 people, 6 people, it made no difference. The concept was, if you're going to be involved in a shootout, we're going to try to figure out a way to go after all of you and not just the person that we know actually fired the fatal bullet. I think this is the only way that we're going to be able to go after gangs. I think it's the only way we tackle drive-by shootings. I think it's the only way that we can tackle some of these club shootings. So this is sort of the premise of what we went out to try to find when it came to mutual combat and trying to prove a way to go about proving everybody involved in the case instead of just the shooter. So the case that brings us to that, and the case in which the South Carolina Supreme Court has recently issued an opinion that now gives us, I think, that ability, is the State versus Aaron Young. So what I'm going to do is, first of all, and I know I did this 2 years ago at the Solicitors Conference, but I want to refresh everybody's recollection about that case. And for those of you who are new, this will be the first time you see it. I am, and I've lectured on this, and some of my assistants are here with me today. I've literally been lecturing to them for like this entire month. They hate COVID on a totally different level than you people do, because I have had them in this room lecturing to them about everything from, and my other senior assistants have as well, everything from Jackson-Deno hearings to trial advocacy. And in those lectures, I've stressed the importance of starting your case with something that not only gets the jury's attention, but it cannot be cross-examined, but gives the jury a general idea about why they're there. Most jurors want to know that. So what I'm going to do is I'm going to run through very briefly how we tried this case, and hopefully it'll also give you an idea about what the case is about.
Now, 911, where's your emergency? Hello?
Hello.
Yes.
My name is Kathleen Faces. Calling from Peregrine Point off of Marshland Road.
Yes, ma'am.
And Allen Road borders on our neighborhood. And we just heard 8 gunshots in rapid succession coming from Allen Road, right behind one of the homes here in Peregrine Point.
Okay. You said about 8 in succession?
Yeah, real quick.
Okay. Did you know what kind of gun it came from?
I have no idea. I think it sounded like a pistol, but it didn't sound like a rifle or a gun. It sounded like maybe a .40 caliber pistol,
Okay.
9mm even, it could have been. But, because my husband and I have those. But it was close to the entrance of, one of the first houses on Allen Road where you go in, because it was directly behind one of the first 3 houses on our street. So it would be like near the beginning of Allen Road.
Okay.
But it was definitely gunshots.
Okay.
And they're always doing that down there. But, there's kids here.
Right.
And I don't know what's going on with those people, but...
Okay. I'll have an officer come and check the area for us, okay?
Thank you so much.
Thank you.
If you need to talk to me, have them come on in.
Okay. What's your address, I'm sorry?
23 Peregrine.
Okay. All right. I'll let the officer know, okay?
Okay, thank you very much.
Thank you.
Bye.
Now, 911, where's your emergency?
It's to make a call with possible gunshots.
Okay. What's...
Yes, ma'am. It's over on Allen Road. It's off Marshland Road.
Okay.
And the multiple gunfires.
How many did you hear? Do you know?
Oh, gosh. How many, John? 6 or 8. It's like automatic weapons, like boom, 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 you know what I mean?
Okay.
And then it was at one end of the road, and then it sounded like they drove to the other end and
Okay.
fired again.
Just now?
So, just now. I just thought maybe somebody should check it out.
Yeah, we just got another call in reference to that. We have officers in the area for it, okay?
Did someone else call in?
Yes, ma'am.
Yeah, it was bad. So okay, thanks.
Thank you.
Bye.
Bye-bye.
Yeah.
911, where's your emergency? Ma'am, ma'am. Ma'am.
We need an ambulance.
Okay, what's going on?
Somebody got shot. I don't know what it is.
Okay, who got shot?
No, come get the ambulance. I don't
Okay,
know what it is.
ma'am, listen to me. Is it the person in your house?
No, it was a little boy outside.
Is it a little boy outside?
Yes.
Okay, is he white, black, or Hispanic?
He's black.
Okay.
What color hat on? Wait. Okay.
Where is he shot at? Do you know?
He's laying. He's laying there. I don't know when he shot it. He's not.
Okay, listen to me. I need you to go to him. Can you go to him?
I can't. I can't do it. I can't do it.
Ma'am,
Yes.
do you know where he's shot at?
I don't know. He's bleeding from his nose. We heard gunshots. We heard about 10 gunshots.
Right. Okay, can you see him?
I can't see him. He's right in front of me.
Okay, listen, is he breathing? They're on the way. Hey, they're on the way. Do you know where he's shot at?
I don't know.
Where is he shot at? Ma'am,
Yes.
is he breathing?
He's not breathing.
Did you want to give CPR instructions?
I'm a nurse. I know CPR. He's not breathing.
Okay, he's not breathing.
So. Please, come, please.
Ma'am, they're on the way. Do you know what happened? Do you see a car that came into the area?
No.
Okay. Do you know the child?
I don't.
Okay. Calm down for me, please, okay? Because I need you to try to get some information for me. Where is he shot at?
I don't know. Stop asking me these questions. I don't know.
Miss Washington?
That's not Khalil.
I'm still on it.
No.
Yes, ma'am.
He got shot in his mouth.
Okay, he's
No, no. That's Khalil. Oh, my God. Is that Khalil? Oh.
okay. So did you see any cars in the area? Okay.
That's Khalil? Oh, no. 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 He's not his name. No. Oh. He's not my cousin. I know him. Listen, he was the guy who had on a red shirt. Listen, do you feel that was serious? No, running over there. Get right over there. Get right over there.
Miss Washington?
What is that?
911 was your emergency.
We have a lady on the line who has some information about where the shop is fired from.
Okay.
You see a green truck and a green Lexus.
A gray
Head towards Sandy Wells, and she do know one of the
gray truck and a green Lexus.
green truck and a green Lexus.
Okay, say it again. Gray truck
And a green Lexus.
and a gray Lexus.
Yeah, she said the two vehicles at each other.
Two vehicles were shooting at each other.
Yeah, and she said she saw one of the people that was drunk.
Okay, and the vehicle went towards Spanish Well?
Yeah.
Okay.
Ma'am, oh, Lord, give the dispatcher your information on who was driving.
Ma'am. Hello, ma'am. Take a deep breath for me, okay? Take a deep breath for me. Ma'am. Take a deep breath for me. I want to help you. Now, who do you think the possible shooter was? The driver in the gray Lexus is Tyrone Robinson?
Yes, no.
You said Tyrone Robinson. Okay, and you said it was a gray truck? Okay, the Lexus was a part of the shootout? Okay, listen to me. I need you to be calm and give me some information, okay? Okay, it's okay. Listen. Ma'am, what is your name? Ma'am, calm down for me now. What is your name? Listen, ma'am. Hello, ma'am. 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 Hello.
The reason that I always, or I number 2, you have now heard a microphone talk. Is it? We're good? Okay. In that 911 call, you hear first shots fired, which is what neighbors are hearing. They don't know what's going on. They only are able to hear the shots. You hear a description of those shots. Not only do they happen at one end of Allen Road, they also happen at the other end. So you hear this continuing gunfire going back and forth. And then with what turns out to be the victim's cousin calling in and saying a child's been shot. This gives the jury a full picture of what we're about to prove as the case, but it also gives, and it gives them the understanding of how serious this is. It is absolutely admissible under 803 subsections 1 and 2 for both excited utterance and present sense impression. The only question would be whether or not its prejudicial value is outweighs its probative value. People calling in a crime scene as it's happening is always going to be extremely probative. The fact that they identify shooters, one being Tyrone Robinson, the other one being 2 people in a gray truck. All of this is obviously probative. The question is it overly prejudicial? It is real. It is raw. It is concerning. Basically, it's the truth. And from that perspective, we didn't have any problem getting it into evidence on the 3 trials that we tried. So let's go first of all what the people at the scene saw, and let me first tell you about the characters of the people that were involved. And let's start out with something that we as prosecutors always start out with, which is the victim. The victim in this case was, go ahead and hit the, was an 8-year-old boy named Khalil Singleton. Khalil was an IB student at the local, at Hilton Head Elementary. He was actually visiting relatives on Hilton Head. This was a Sunday. It was just one of those days where he's playing with two of his friends, and they're literally playing outside of one of his relatives' house when all of this takes place. That was his crime, being in his own neighborhood this Sunday, basically around sometime late in the afternoon. The person who actually shot him, the person who fired the fatal bullet, was this next man, Tyrone Robinson. And I appreciate Solicitor Clements talking about our work at the General Assembly. What I have said to the General Assembly so many times I can't remember is that we honestly need truth in sentencing in this state. And Tyrone Robinson is the poster child for why we need truth in sentencing. Tyrone Robinson spent his entire adult life in prison. He was convicted starting in 1995 all the way through 2002 for 13 separate crimes, 3 different events. He was paroled. We lost it. He was paroled 4 times. He violated parole 3 of those 4 times. The only reason he didn't violate the last one was because his sentence ran out. Otherwise, he would, I'm sure, have violated that as well. His last series of crimes were 3 crimes in which he went to trial, he was convicted, and all 3 of those charges carried an accumulated sentence of 13 years. The judge on the bench was Judge Jack Gregory. Judge Gregory was a good judge. He was not particularly a heavy sentencer. He was a pretty middle-of-the-road sentencer. He was so offended at Tyrone Robinson and what he did that time, what he had done in his past, his criminal history, that he literally said from the bench, "You are dangerous, you're what makes our streets dangerous, and you need to go to prison and you need to stay there. And I'm going to give you every single day I can." He gave him 5 years on one offense, 5 years on the other offense, and 3 years on the other ones. Not only did he give them the maximum sentence on all 3 of those charges, but he ran it consecutive. And we all know from our experience in criminal court that that rarely happens. That's how serious Judge Gregory took this man. And when he sent him to prison, he sent him in for a 13-year sentence. But here's the problem. of all of the 13 previous convictions that Tyrone Robinson had, in South Carolina, we don't consider those violent offenses. And as a result of that, he's parole eligible, despite the fact that he clearly shows he's not somebody that should be eligible for parole. He serves a 7-year sentence, and on year 9, he shoots and kills Khalil Singleton. Now, the other 2 people involved, he doesn't do this by himself. He's the actual trigger person, and we know that, and we go into the trial knowing that. The other 2 people are Aaron Young Jr. and Aaron Young Sr. Now, Aaron Young Sr. was no choir boy either. 2 counts, 2 previous convictions for domestic violence, possession of crack, possession of other drugs, and resisting arrest. Aaron Young Jr.'s son, there's no need for me. He didn't have an adult criminal history, but he was interviewed by law enforcement shortly after this shooting took place. He is in the interview room, and he's literally talking to himself when he says the following things that I'm going to show you. And I don't need to, this probably summarizes him better than anything I could do.
Should have never moved my ass from originally. Should kill as many people I want to, and nobody never fucking find out. The gun had jam on it. I'm not a worker gun, I'm not stupid. I know how to work this shit very well.
For Aaron Young Jr., here's your helpful tip for those of you who are assistants and even senior lawyers who work with law enforcement on a regular basis as they're developing cases. They constantly talk about making sure you read somebody their rights, interview techniques, various things like this. Law enforcement studies interview techniques. They spend a lot of time trying to get this down. How do you get somebody to talk to you? Here's my best advice to law enforcement if you get the right person, and Aaron Young Jr. was clearly the right person. Here's my advice to law enforcement. Shut up and leave him alone. Don't say anything. We literally were watching this video after the fact, and as you could tell, Aaron Young Jr. was in the room by himself. He's talking to himself. They've got him videoed. They have the audio. And we're watching the investigator walk into the room, and literally we're all screaming, "For God's sake, don't go in there. Let him talk. Let him talk." Because he gave us, to me, a much better summary of who he is than anything we could have ever brought out of him. I mean, he made statements to law enforcement, but I assure you, none of them were as good as, "I could have killed anybody I wanted to in Ridgeland. I shouldn't have left. And I know how to work that gun. It jammed. I know how to work it very well." I mean, these comments, I think, give you a really good idea about who we're dealing with. So, you've heard the 911 tape, but let me give you a summary of actually what happens. There is a lady, and first of all, when we went out to investigate this case and to start getting ready for prep, there's a problem in Hilton Head that many of you have as well. We don't cut trees here. We refuse to cut any trees. So therefore, if you get an aerial view, a tax map of any neighborhood in Hilton Head, you're going to see nothing but a big green blob. We went out to the scene and started talking to witnesses. Tell me what you saw, what you heard, that kind of thing. And we were getting them from all different directions. Everyone heard a little bit different, things a little bit differently. Everybody saw it from a different perspective. And we couldn't really get good crime scene photos from any of that. And literally, we're out in the neighborhood trying to look. Several years ago, I learned about the FBI crime lab, the the crime scene documentation lab. This is a group of people in Quantico that build models. They help you develop crime scenes. They did the Oklahoma City bombing, the Murrow building. They actually built a mock-up of the Oklahoma City bombing case, complete with little people, desks, chairs, the whole bit. When I contacted them, they had just got through building the house in which the man in Cleveland who had kidnapped the two girls at a young age and had basically kept them there for a series of years, they had just got through building that house so that the Cleveland prosecutor could use that. When I called them, I said, all right, and I talked to the head person there. I said, look, I need help. Have you guys ever done a neighborhood? I mean, I don't need a house. I don't need a trajectory. I need an entire neighborhood. And they said, well, no, but we'd be willing to give it a shot. I said, great. They said, when do you need it? I said, in a couple of months. They said, no, absolutely not. We don't have time to do that. I said, well, I certainly understand that. And we had already been scheduled for trial, so it was one of those things that we didn't feel like there was going to be a continuance. We were going to be ready to go on it. So I said, thank you very much. I appreciate it. But before I hung up, the lady said, what's this case about? And I said, it's about an 8-year-old child who was shot and killed in a crossfire among 3 people that were shooting at each other. And there was a pause. And she said, we'll be down there next week. And when they come down, let me tell you, they really come down. Go to this next thing. This is part of the team here on this left. This is something from their website. It doesn't snow like that in Hilton Head. But this photograph on the right of the left of your screen, that's part of their team. Their team came down from Quantico, Atlanta, Charleston, and then we had the resident RAC as well that worked with us on this case. They execute search warrants on everything. Everything that they do is exactly in proportion to everything else. They execute search warrants on the house to make sure that the window is in the right proportion with the doors and everything like this. So they created this model, which we used in not 1, not 2, but 3 separate trials in the case. The lady that lives, and I'll go now to this model, the lady that lives here in this house, her name is Charlize. Charlize has lived there her entire life. And she knows everybody. She was a great second witness because she was able to come out and say, let me tell you, I live here, and I'm going to tell you who lives here, and cousin Eloise lives over here, and she went through the entire neighborhood. She was a great witness. Number 1, because she knew everybody in the neighborhood. Number 2, because she actually knew the shooters as well. She was also related to Tyrone Robinson. She was also related to the Youngs. And here's how she basically broke it down. She said she's here at her house and she hears gunfire, the same gunfire that you've heard described in the 911 calls. Rapid fire. She knows that she's got 3 kids out here on this trampoline, and those 3 kids belong to the neighborhood, and therefore they belong to Charlize. So she comes out to the front door and she yells, get inside, get inside. Well, one of them actually does belong to her and comes into her house. The other 2 belong in houses over here throughout this neighborhood. So they take off running this way, away. She says that she sees Tyrone Robinson previously because Robinson had already come by her house saying, I'm looking for the Youngs, and she saw the gun on him, and she shooed him away. She hears the gunfire. She tells the kids to run. 2 of them take off in the wrong direction. Khalil Singleton had a four-wheeler, and this is the red four-wheeler here. He got all the way over in this direction before he realized that he left his four-wheeler. The other kid continues to run. Khalil turns back around. What had happened, Tyrone Robinson driving the green Lexus, which was described in the 911, he had been in a shootout with the Youngs in their truck here. They had chased him into Allen Road. He had parked behind one of the houses where he abandoned his car and walked off into this neighborhood. The Youngs came down, and the first series of gunfire that everyone hears are the Youngs pulling behind, finding Tyrone Robinson's car and shooting it up. They called it Swiss cheesing the car. Shooting multiple times out of a gun that the ballistics expert testified would fire literally as quick as you could pull the trigger. They didn't see Robinson, so they pulled back out on Marshland Road and were driving back down here when they got just about right here. Khalil Singleton had already run across, but what nobody knew was Tyrone Robinson was waiting right here. And so when the Youngs drove by, Robinson takes a shot at the Youngs at the exact time that Khalil Singleton runs back across in front of him. The bullet catches Khalil in the side, cuts through every one of his little organs, and he bleeds to death literally in the driveway right there. Shirley sees most of that. She doesn't really know, obviously, where the shooter came from or any of that, but she sees all of these people. She knows the Youngs because they're related to her as well. So she describes seeing them driving past the neighborhood when the shooting takes place. What she nor any of the other witnesses know, however, is that This is not a situation that happened in a vacuum. This is not just a shootout here. So what we do is we go back now to how it all started. The first address that you need to know is Wild Horse Road area. This is actually Aaron Young Sr.'s house. He and his son and some other people were over on this Sunday afternoon when Tyrone Robinson came and visited. What you need to understand about Tyrone Robinson is not only is he a career criminal, not only is he somebody that we look at and say, this guy needs to be in prison, everyone in the neighborhood felt the same way as well, including the Youngs. The Youngs didn't like Robinson any more than anybody else did. Robinson comes over to the house. He's drunk. Apparently it's his birthday. He comes over to the house. He gets in an argument with Aaron Young Sr. Tyrone Robinson pulls out his own handgun and shoots at Aaron Young's feet. Now, had Aaron Young at this point in time pulled out a gun and shot and killed Tyrone Robinson, there wouldn't be any charges. I think that's classic Castle Doctrine case, and even if it isn't, good riddance, we're moving on. The problem is they didn't do that. They didn't shoot him there because they didn't have their gun with them. And what they also didn't do, which particularly offended me, was they didn't call law enforcement. They didn't call anybody. They didn't call 911. They went and got their gun. The gun was in a bag. It actually had to be assembled. They hand the gun. Aaron Young Sr. hands his gun to his son. They both load into their pickup truck and they go hunting Tyrone Robinson. They leave their house here. They get on the Cross Island. They live on a road that goes parallel to the Cross Island Expressway all the way down into the Oakview Road area. Robinson in the green Lexus, the Youngs in their truck. When they get to the Oakview Road area, they actually see Robinson. Robinson is going in the opposite direction. As he's coming by, Aaron Young Jr. holds the gun out of the road, out of the window of the truck, and tries to fire and kill him. That's when the gun jams. It doesn't work. They keep going, they keep looking for each other, and eventually they end up back at the Allen Road residence. As it's described, as we describe it, this was basically a running gun battle. It was a gun battle between two people who wanted to kill Tyrone Robinson, and Tyrone Robinson who fired back at them. When it came time to charge, we had recovered that gun. This is the gun that the Youngs assembled in the truck that jammed, but it's also the gun that will fire as many bullets as you can pull as quickly as you can pull the trigger. This is also the gun that they used to Swiss cheese, as they called it, Tyrone Robinson's green Lexus. We recovered that gun. The Youngs actually gave us that gun, gave law enforcement that gun, because they knew they didn't shoot the kid. We run the tests on the gun comes back and proves that it wasn't the gun. Now, obviously the Youngs could have had another gun, but we really didn't think so. If you look at the model and you look at the way everything's laid out, it was pretty clear that Tyrone Robinson was the one that actually shot and killed the boy. It worked well. It worked with the pathology report. It made sense. So we were very confident that the trigger person was Tyrone Robinson. So charging him with murder was easy. We charged Tyrone Robinson with murder, we tried him, and we convicted him. But here was the problem. And it was interesting because the defense attorney actually called me and said, can we come by and talk to you? And I said, who's we? Me and my client. It's like, really? Yes. The defense attorney brings Aaron Young Sr. to my office and sits down with me because he wants me to understand that he hated Tyrone Robinson and that Robinson killed the child, and he didn't understand why he was being prosecuted. It is probably the only time I've ever actually talked face-to-face with a defendant, with their defense attorney. You see it on television all the time. Never happened to me. At that point, I realized he didn't get it. Because in my mind, there is no real difference between Tyrone Robinson and Aaron Young. They're all shooting at each other, and an innocent child dies because of it. But the difficulty is, in South Carolina, again, we really don't have the legislation to help us tackle that. The only way we could figure out how to do it was the hand of one is the hand of all. Let's charge the Youngs under accomplice liability under the standard of the hand of one is the hand of all. Here's the problem. As we were researching this and as we were preparing the case for indictment, the words that just kept hitting me over the head were, by his Confederates. Hand of one is hand of all is traditionally for the guy who goes with the getaway driver to the armed robbery. The guy goes inside the store, he shoots and kills the store owner, he gets back out. So you hold the getaway driver accountable as well under accomplice liability. Basically, everyone is responsible for what the shooter did, but they're working together. And in this situation, Aaron Young and Aaron Young Jr. were not working together with Tyrone Robinson. They were very much apart. So the concern we had was that that the hand of one is the hand of all under our traditional accomplice liability theory wouldn't work. Hunter Swanson was working with me on this case, and Hunter went off to do the research. Felony murder rule doesn't really exist in South Carolina. If it does, there's clearly language that calls it into question. I wouldn't base my whole murder case on it. But she found something that I thought was interesting. A case from 1915, not 1950, mind you, 1915, involving a strike that took place at the Judson Mill in Greenville County. The strike, there were a bunch of people that were working in one section of the mill that went on strike. The strike lasted for about 20 days. At the end of those 20 days, most everyone went back to work, but you still had a handful of people, fellow employees, who were still striking. Well, that day there seemed to be an opportunity for those people that were still hanging out striking to go and have a little conversation and talk some smack with the people who had gone back to work. Well, that escalated, and it escalated into a fight. But what was relevant about this is that during the fight among these employees and some strikers, some not, somebody yells out, "Look out, men, Harvey has his knife open." Now, I don't know, back in 1915, it's a lot like, I'm from Horry County originally, and I know Horry County is all together watching. It used to be, if you entered into Horry County and you didn't have a knife, they'd give you one when you walked in the county. So that may have been the whole situation, but that's a relevant piece of information, because somebody at this point is announcing there are deadly weapons involved, and everybody hears it. They get in a fight, somebody gets killed, and I had to put this language in here just because I found it particularly interesting. Law enforcement goes to the scene, they find a guy who has been stabbed, and he says, "I am cut to death and killed." What beautiful language. It's like from a really bad movie in the 50s. "I am cut to death and killed." And then he identifies two of the people that stabbed him. The solicitor there, D.A. Bonham, actually brought charges against all 5 people that he knew were involved. And he charged all 5 of them with murder. And he charged them under the theory of mutual combat. What I will show you now, and the jury actually comes back and convicts them all 5 of voluntary manslaughter. The jury charge in this case was this: everyone is presumed to know the consequences of their act if they voluntarily enter into the fight, into the mutual combat. Deadly weapons are used. And here's the third part that's important. Everybody knows that deadly weapons are involved. And the death results from one of the participants. And then one of the participants becomes something particularly relevant. What I also thought is interesting about this mutual combat charge is that it also states that whether the participant actually used a deadly weapon or not. So if you've got 5 people, there are deadly weapons involved. All 5 were charged even if they didn't have the weapon themselves. So this was an interesting jury charge. It was one that was upheld, and then later on, Aaron Young's case, the Supreme Court actually cited it. They also brought this point across as well. To constitute mutual combat, it's not necessary that there's some kind of positive agreement. It can happen upon the impulse of the moment, and that will be particularly relevant when we talk about the dissent in this case. So, we indicted the Youngs under the concept of mutual combat. I need to stop there and to make sure everybody understands something, because this is crucial to this. And go back to that slide, because that's important. If you've been in this business for a long time, you already know the term mutual combat, but you know it in a different way. As everyone knows, self-defense is, there are elements to self-defense, and the very first of which is you are not at fault bringing about the problem to begin with. You cannot claim self-defense if you bring about the problem. If you agree to a duel, you cannot then, in the midst of the duel, claim, "I shot him because he was going to shoot me." You don't get self-defense because of that. That preclusion to self-defense is called mutual combat, and we have known that for years. That's something that has not fallen out of favor in South Carolina. But what we are trying to do here is not just do that, use that as a preclusion to self-defense, but also establish it as a basis for a murder conviction. And that is something that's particularly important because I think you're going to see some confusion in subsequent criminal cases. You're going to see the defense, I assure you, will bring that up. Judge, what this is a defense basically to self-defense. It is, but we're talking about two entirely different things, and you need to remember that because it's important. Here, in the Aaron Young case, once we tried both of those individuals and we convicted them, they appealed, which we of course knew they would. And here are the two issues. Can mutual combat form the basis for a murder conviction and not just a limitation to self-defense? And number two, can it then be extended to a non-combatant? As you recall in that jury charge under mutual combat, they say every participant is responsible for the death of any other participant. Khalil Singleton's not a participant. And we'll get to that in a minute, but I didn't think that was going to be the particularly difficult part of this. I didn't think we were going to fall off on that. I was more concerned with this first element, the first issue, which is can it form a basis for a murder conviction, because it had not been used, as far as we could tell, since 1915. So the case goes up on appeal. It goes to the South Carolina Supreme Court, and the Supreme Court, with Acting Chief Justice Kittredge, issuing the opinion. I normally do not, in a presentation, quote as much language as I am today. But I love this language. He did such a good job understanding not only the concept that we were trying to push, but then giving us sort of a blueprint of how to go forward. So here is the holding in Aaron Young, and this is what I think now becomes a totally different perspective and a much improved perspective on what we've done in the past. We therefore find the deadly homicidal force here was not a single bullet that struck and killed the victim, but a collective fuselage that spanned over several neighborhoods over the course of an hour. A combined hail of bullets that result from such a battle are jointly responsible for the fatal injury. And here's my favorite part. Such that the determination of which defendant's bullet actually caused the death is unnecessary. So this language in itself, and leave that up there just a second, this language in itself kind of gives the overall concept of what we were pushing, which is it's not a single bullet that actually killed Khalil Singleton. It was what I was trying to convey to Aaron Young Sr. when he's sitting in my office. You are just as responsible for that child's death as the guy who actually pulled the trigger, because had you not been chasing him, had you not chased him from your house all the way up well past Highway 278, about probably 10, 15 miles till they finally got to the Allen Road area, there would be no reason for him to be shooting back. And this is the type of thing that we deal with on a regular basis. We have club shootings in which somebody brings out a gun and shoots in the air or shoots at somebody else, and then everybody else pulls out their guns and they start shooting. Without all of those people doing that, the fight doesn't continue and people don't die. It takes literally two people to cause the death like that. And that was kind of the concept that we were going. So the idea that they found that and held it in that way, I think, is particularly important. Again, the court goes on to say that both the Youngs and Robinson voluntarily and jointly created a battlefield that encompassed any number of innocent and unwilling bystanders, including young children like Khalil. And this, I think, is also great language that we can use in the future. The Youngs and the Robinsons' collective actions in carrying out the gun battle, it's reasonable for the law of mutual combat to serve as a foundation of a murder charge, to hold each one responsible for both his own action and the actions of the other. Go to the next one. We find the deadly force used in this case was the result of a collective action. We hold the responsibility for the victim's death as collective as well. So that concept of a collective action and collective responsibility the court ties in. And then the final holding, obviously, is that Young Jr., and by the way, Young Sr.'s case was on appeal as well, and it's on the exact same issue, so I expect this to come back the same way, was properly charged under the theory of mutual combat. What this, I believe, does has moved a concept that was used in 1915 all the way to present day. I think it gives us a way of going after groups that shoot at each other, and in particular that don't shoot particularly well and end up shooting innocent victims. But there are some limitations on this, and you need to understand the limitations as well. Well, first of all, I apologize, I was skipping ahead. Second issue was something that I didn't really think was going to be a big deal. Again, mutual combat from 1915 said you're responsible for the death of any other combatant. So if you got 4 people shooting at each other and somebody gets killed, everybody else is responsible for that person. And it also didn't matter what side you are on, which I thought was particularly relevant. So if you got the Youngs and Robinson, they're on different sides. Under the concept of mutual combat, it doesn't matter. It doesn't matter if they're on the same side or not. So it covers that basis of the hand of one is the hand of all. It covers that concern that we had that, well, it only applies if you're working together and not against each other. In this situation, what they're doing together is the collective battlefield that Justice Kittredge explains. So in that context, the next question is, can the use of the legal theory of transferred intent also work? Because, again, one of the combatants wasn't killed, Khalil Singleton was killed. What I thought was pretty interesting in this, and I love it when the court actually speaks out and says, let me take just a moment to tell you how smart we think the trial judge was. We had Judge Tommy Cooper, which I think most people would agree is one of the best, if not the best, judges on the bench today. He was particularly patient in a very difficult and complex case. We tried this case not once, not twice, but 3 times, spanning over about a 6-month period. We actually had an initial try to try them all together, and there was a discovery issue with some information that didn't come to us, so therefore it didn't go to the defense, and that case got continued. So we had 4 active court weeks spent on this particular case, and he stayed with us throughout all of it. At the end of which he walked up to me and he said, do you think maybe next time we try a case it doesn't have to be a law review project? And yeah, I appreciate that. But he was an outstanding judge, and the Supreme Court recognizes that although the experienced trial judge recognized the facts of this case represented an extension of the existing law, he found Young Jr. could be held liable for the murder of the victim based on the theories of both mutual combat and transferred intent, which takes us out of the actual language of the mutual combat in which only the combatants would be held liable. And here's the relevant language. It's not the identity of the victim that's relevant. It's the intent or the state of mind of the shooters, of the mutual fighters. So if they've got the mutual intent to fight, then they kill somebody that's not in the fight, they're all held responsible. So that's what that case gives us. There are some limitations, and the first of which is withdrawal. The defense wanted a charge for, well, okay, well, I'll agree with you that there was a mutual combat at some point, but when the Youngs got into their truck and started driving away, they were withdrawing from the fight, which probably would have worked a little bit better had they not already been chasing people through the 10 or 15 miles it took to finally get to Allen Road. Had they not already taken a shot at him at one point, but the gun jammed and it didn't work. Had they not already Swiss cheesed the car. The idea that they had stopped and they were simply leaving was something that the defense wanted as a charge to the jury, and we were obviously adamantly opposed to it. What is important about withdrawal, though? It is real. If you are involved in mutual combat and you withdraw, you're no longer responsible for what happens with the other people. You also get your self-defense claim back. You're back to being a normal human being. However, here's how you have to withdraw, and this is particularly important. You have to, in good faith, decline further conflict, and by word or act, you have to let the other side know it. Now, I'm not even sure how this would have worked in the real world. I don't know if the Youngs would have had to yell out of their truck, hey, Tyrone, we're done here. Stop shooting at us. The testimony actually was just the opposite of that. After they heard the shot from Tyrone Robinson that killed Khalil Singleton, they obviously did not know Khalil Singleton was dead, although they knew children were in the neighborhood. Part of what they... Yes?
May I interrupt with a couple of questions?
Yep. Yep.
One is, what if the shooter is firing in valid self-defense, and what if the stray bullet hits and kills an innocent bystander?
Well, and that self-defense claim is what we have to fight about in this mutual combat. If they have agreed to fight, and the agreement can be something that took place immediately, if they do that, they don't have the self-defense claim. They don't have it primarily because they were at fault for bringing on the difficulty. But the other issue there is that if again, it goes back to the state of mind of the person when they're firing. They may be firing in self-defense. Tyrone Robinson claimed, well, the only reason I was shooting at the Youngs were because they had shot at me. However, he also leaves out the fact that he had shot first, and I don't even know that that's important. I think what is crucial is you've got people that are armed. Young was armed and Robinson knew it. Robinson was armed and the Youngs knew it, and we had plenty of testimony indicating it. And they, at some point in time, shot at each other. I don't think you cannot at that point stop unless you withdraw. And that kind of gets me back to, let me go back to the thing. In order for them to claim self-defense, if Robinson wanted to have, or if the Youngs had wanted to claim self-defense, they would have had to withdraw, and they would have had to tell the adversary that they were withdrawing. And what's interesting about that is that I don't know how you do that in the real world of gang warfare, but let's assume for a second that they'd actually done that. Here's what the court held in that the withdrawal has got to be the unequivocal cessation of the mutual combat. It's got to be clear that you say, I'm done here. There's not going to be any more fighting. I'm laying down my gun and I'm walking away. In the real world, how does that happen? I doubt it does, quite frankly. But if it does happen, it's got to be clear. And so if they convey, I know we've been fighting, I know we've been shooting at each other, and it's been going on for a while, but if they convey that withdrawal and it's clear that they're withdrawing and everybody knows it, then they can claim the self-defense. But until they do that, they can't. And if they've agreed on a mutual combat, then they're going to be held liable under this case. Is there another question, or is that the...
There is another question. Sorry, I was muted. As to a mutual combat case, how does stand your ground argument fit in?
Right. Well, again, I think if you go back, the stand your ground was something that I was a little concerned with had the shooting actually taken place at the Youngs' house. If we go back to the very first event where at the Youngs' house, when Robinson comes up to him and shoots and fires at Young, had Young retaliated then, shot at him, missed, and hit Khalil Singleton, I think they would have had a legitimate argument for the Castle Doctrine. I think in this situation, quite frankly, we were a little bit concerned about that, whether or not that would be something that would limit us. But the court was pretty clear on the fact that you know, in order for you to be eligible for the Castle Doctrine, you have to be legally where you're supposed to be. You have to be acting legally when you're establishing your stuff. And at no point in time was Robinson or Young, after they left Young's house, none of them are where they legally should be, doing what they legally should be doing. So I think that guts the underlying concern about the Castle Doctrine. Now, it was not reviewed by the Supreme Court. It wasn't an appellate issue that they used. So there's no real good language offered by the Supreme Court to kind of show where they would go on that. But my theory on that is that they were not legally doing what they were supposed to do to begin with, that both Robinson and Young were acting illegally at the time, and as a result of that, I don't think they would have been eligible for the Castle Doctrine under that concept. It would have been more, at least more intriguing had the shooting taken place at the Youngs' house. That would have certainly meant the Youngs clearly would have had a stand your ground type of argument. Now, again, the withdrawal, that will be something that they asked for. They did not get a jury charge on that. They asked for a withdrawal jury charge. Judge Cooper did not get it because he said, look, as far as I can tell, it wasn't anything other. It wasn't that they, as he put it, they didn't look like they packed up their tents and went away. They looked like they were. No, go back one. They looked like they were continuously shooting at each other, and they may have had a temporary stop just because the Youngs didn't know where Robinson was, but once they started the shooting back, to them, he didn't seem like there was a substantial time there or anything that would indicate that the Youngs in any way were stopping. Again, it's got to be clear that you're withdrawing. And he didn't find anything that the Youngs said that would indicate that. In fact, the testimony was exactly the opposite. After Robinson shoots at and kills Khalil, again, the Youngs are driving here in the truck. They do not at this point know that Khalil Singleton was shot and killed. They just hear a gunshot at him. Young Sr. is driving. Young Jr. is in the passenger seat. And Young Jr. actually says in one of his interviews that I told my dad, turn this truck around, we're going back. Really hard to argue at that point in time that they were withdrawing. In fact, because you've got a shootout on Oakview, you've got a shootout at Whitehorse Road, you've got a shootout here at Allen Road. I think Judge Cooper was absolutely correct, and the Supreme Court found that he was correct, that this was one big, within 1 hour, it was just a series of a running gun battle. And at no point in time did anybody withdraw. They were simply just trying to get a better angle. In fact, the argument could also be made that when Robinson put his car where he put it, the idea was that he would bring the Youngs out so he could take a shot back at them. He wasn't in his car. He was several yards away. And so as that car is getting shot up, he's able to position himself to take a shot at them as they drive back through. So I don't think there was anything in this that indicated withdrawal. Now, here is another limitation that sort of ties in with that, and this is a dissent by Justice Hearn. Justice Hearn stated that she thinks there was a substantial time lapse between the shooting of the car, the Swiss cheesing of the Lexus, and the shooting of Khalil Singleton. Well, another reason I played you the 911 call is I think that should answer that question. If you think about the 911 call, you've got one call where somebody calls in and says, we heard a series of gunshots. The second 911 call, the lady says there was a series of shots, there were a lot of them, and then we heard them shooting at the end of the street. Now, she's making one 911 call. At any point in time, had she heard shots, she would have called. That was an event that triggered her need to call 911 and say, we've got an emergency, I'm hearing gunshots. It happened so closely together that that first phone call encompassed two shootings. So I think if you look at it from a factual standpoint, there's no way that you can say that there's a substantial time from when the Young shot up Robinson's car and when Robinson shot back and killed them. There was testimony, and Justice Hearn mentioned this. Somebody in the neighborhood said, yeah, there was probably about 10 minutes between the shootings. There were so many shootings, it's kind of hard to narrow down which ones were which, but we all recognize when we're trying cases and we have people that are eyewitnesses, elements of time are things that they don't really grasp. Nobody's sitting there watching their clock. 10 minutes to some people is 10 seconds, and I don't know how to prove that other than to say, number one, the 911 call, and then number two, what are the kids doing? The kids are still running. They've heard shots, the kids are running, and Khalil gets shot. They are still running when it happens. It can't be a substantial time frame, but that is an issue that you need to be aware of on the limitation of it. So go back to that. All right, how are we doing on time? 11:25. And when do I go till? 11:40? All right. Let me take this case up too as well. Now this is another issue that you're going to have to tackle, and this goes back to the confusion that we all have because mutual combat has basically been a preclusion to self-defense. Mutual combat in this context, there's yeah.
I'm sorry, there's another question.
Yeah, go ahead.
How much of the statements of the other co-defendants were admitted at trial?
The question, as everybody could hear, was the how many of the statements of the co-defendants were admitted in trial. Obviously, every defendant had a statement in. We were able to get some statements in. Robinson actually goes to the scene after the shooting and is talking to the police officer, telling him what happened. That was particularly helpful, as the officer did not have a body camera, but he did have a car video and audio, and that was picking everything Robinson said. But it's interesting that Robinson basically gave the story that we didn't really want to use, because it was, man, these guys have been chasing me around and they shot and killed this kid. Well, we knew he didn't actually, that the Youngs didn't actually fire, but it was giving Robinson his defense. So we had it, but we didn't use it. Every defendant made some type of statement. We were able to get most of the case in without using their individual statements, but as I recall, we ended up getting, and I need to probably go back and think through it, we ended up getting bits and pieces of everybody's statement in. It was very clear that this was going to be a legal fight and not necessarily a factual one. So we were able to get, and having tried them separately, we didn't have the Bruton issue of having to take out everything that they were talking about the other one. So because we were able to try every one of them, when we had that defendant up on the stand, or on that defendant at trial, we used their statement against them. So we had Aaron Young's statement, Senior, we had Aaron Young Jr.'s statement in those individual trials. And so a good bit of it, we did not have a gap of information on this. We didn't have, everybody pretty much understood what happened. The Young's defense was clearly, you know, this wasn't us. This was, the trigger man was Tyrone Robinson. And if they were trying on a legal end of it to keep us from going to the jury on it, but even if they failed that, the argument to the jury was, look, you know, everybody knows who the trigger man is, and the Youngs aren't that. And by the way, here's what's kind of interesting about that. When we got to, this was one of those rare cases in which the fight was all legal. When it came to the jury, it was complex from a jury standpoint. We actually, and I don't always do this, in fact, I very rarely do this, but we actually did a blow-up of the mutual combat jury charge, because we knew that concept was complex. But what's interesting is for the jury itself, the actual concept was pretty easy. Because what we talked about in the closing argument was, you know, as a child, if your mom tells you not to run through the house and you got all your friends over and you go running through the house and you break a lamp, your mom couldn't care less which one of you actually hit the lamp. Everybody's going to get a beating, or at least they were in my house. My parents still would be not eligible for parole. But anyway, point being is that everyone understands the concept of everyone working together, everybody being held liable when they're all doing something they're not supposed to be doing. And in this case, we're not breaking a lamp, we're breaking a family. And so the jury itself, and I've talked to jurors about this case afterwards, and everybody understood the concept. Although legally it sounds very complex, from a practical standpoint, the jury got it sort of right off the bat. Any other question right now? Or? All right. Let me go to another limitation, and this is going to be the confusion, I think, that, and this case was just recently reviewed and overturned by the South Carolina Court of Appeals. Hunter Swanson, the same prosecutor that came up with the concept or found the 1915 State versus Brown case, turned around and tried Joey Bowers. Joseph Bowers was a club shooting case. It was a shooting in which everybody, again at the end of the night, last call is signaled by a hail of gunfire. Somebody actually brings out a flare gun to start the fight this time, shoots the flare gun, and then everybody else starts shooting back and forth. Obviously mass confusion. As the court recognized, they had verbal altercations at a local club that escalated to a shootout. 2 people were killed, Dante Bailey and Michael Morgan, and 2 others were injured, Robert Goodwine and Richard Green. In the case and during the trial, there was evidence that the defendant was holding a gun. The defendant, when interviewed, said somebody else was shooting. But, and I don't know how many of you, I think a lot of people at this point, maybe everyone, listens to jail calls. If you don't, for goodness sakes, do that, because we listened to jail calls for months. And it wasn't until probably about 6 weeks before the trial itself that we got this one. He's talking to the defendant is talking to his girlfriend, and he's visibly upset. Trial's about to start, the stress is getting to him, and he makes a statement to his girlfriend. I don't know how, she asked him, how did you get into this mess? And he said, man, I don't know. He said, you know what? I shot the boy, but I didn't kill the boy. Well, in our field, that's a touchdown. That's a confession. And so we actually had testimony, and Hunter had testimony, that not only was he holding a gun, he was in the middle of a gunfight, and he actually acknowledged that he shot one of the victims, although he claims he didn't kill him because the hospital did that because they were not able to revive him. That I've never seen that theory work, but it's shocking that people still try it. So anyway, in the Joey Bowers case, the Court of Appeals, and it's important that this is a Court of Appeals, and it is on review right now. It's on cert with the South Carolina Supreme Court. They found that a mutual combat charge was improper because there was no evidence of a previous agreement to fight. There was no evidence of pre-existing ill will between the defendant and the victim. And it was particularly, and I think this language gives you the best idea, the erroneous charge on mutual combat was prejudicial because it effectively negated the defendant's self-defense claim. I think that the Court of Appeals confused mutual combat as a substantive way of proving a murder conviction with a defense to self-defense. And I think, honestly, that the Supreme Court's going to go back in and overturn that. I think, go back to this language a little bit, those are not elements of mutual combat. And in fact, if you recall back on the elements of mutual combat, one of them was that the mutual combat, and this was from the State v. Brown case, which cites back all the way to State v. Cook. And go to the next slide. To constitute mutual combat, it's not necessary that there's a positive agreement between the participating parties. It's sufficient if they willfully enter the conflict upon the impulse of the moment. So I don't know how you have that language on one hand, establishing a basis for murder based on mutual combat, and at the other end, the Court of Appeals says, well, there's got to be some kind of pre-existing agreement to fight and all that. There is in the world of self-defense, but in the world of a substantive way of claiming mutual combat for murder, I think they just confused it. And again, it's on review for the South Carolina Supreme Court. And I think that, I honestly think it's going to get overturned. I hope it does. Now, the one other thing that Aaron Young's case does for us is we think of it in terms, obviously, in a shootout. But there is an extension. And I don't know about you, I love footnotes. I love reading the footnotes on Supreme Court cases because always in the footnote, they put in something interesting that gives you a little bit of a theory about what they're thinking. And in this case, in Aaron Young's case, the State v. Aaron Young, footnote number 4, show up this, it talks about a case out of New York. And what they reference, the case in New York is called Abbott. And what they talk about in this case is a car race. There are two people who agree to race. And in the process of that race, one of the people drives off the road and kills an innocent bystander. And in the Abbott case, what they found was that because the other person driving the car, obviously the guy that drives the car runs off the road and kills somebody, you've got that vehicular homicide. What about the other person that was racing that didn't kill anybody, that didn't run off the side of the road? What the Supreme Court said that, or what our Supreme Court references, is that when the defendant accepted his rival racer's challenge, when he said, yes, I'll race you, he shared in the venture. So now you've got that collective effort. And the question is, will that also be collective liability? Without the defendant's aid, the rival racer could not have engaged in the high-speed race. And therefore, they never would have had the tragedy. The accident was a culmination of a continuum of events in which both racers participated. What they have taken there, and with this footnote, I think what it tells us, is that this type of approach can be used not just in gang shootings. It doesn't have to be used in a shootout. It can be used in any situation in which you have groups of people with criminal activity that is particularly dangerous that causes the death of somebody else. And so I think what Aaron Young's case gives us is a way of not only going against the club shooters, not only going up against the gangs, the drive-by shootings, but also any situation in which we've got people collectively doing what they shouldn't be doing, which is illegal, and that activity is particularly dangerous in causing the death. The last thing I'll leave you with is this, and I'm going to send out a good bit of this to everybody because I want everybody to have. I'll send you the jury charge, the indictment. We prepared the indictment in a particular way, and that's relevant as well. So I'm going to send that to you. The opinion, the memo that we used. I'll get all of that material and get that out. And I'm sorry that I haven't already done that. In my office, and I told you guys this a couple years ago, but it's particularly relevant to me. In my office, I don't have my diplomas on my wall. They're nice and they're important and all, but what I have on my wall are notes that I've received from people that have really meant something to me. In this case, Caleb Moranti was a kid that was in school with Khalil Singleton, and he sent me this note right after this happened, and right after we prosecuted Tyrone Robinson. Interestingly enough, he sent me a note after every single trial. And in fact sent me his grandfather was a clerk of court in Georgia and had a painting in his office that they donated to the solicitor's office. I have this on my wall because honestly, this is why we all do what we do. This is, to me, this brings the heart into the matter and shows the importance of what we do on a regular basis. And I think I want to thank everybody for listening today. I want to tell the young assistant solicitors in my office as well out there, this is what we do is important. Last year I talked about small groups of people that change the world. And those small groups of dedicated citizens that have changed the world are the people that only ever have. And you guys are a part of those groups. And thank you for what you do. Speaking of which, the next thing up is an award ceremony, recognizing, again, the people in our organizations that are changing the world and have made this, our criminal justice system better and have made it our community better. And I will congratulate them on their awards, but I will now turn it over to my man, David Stumbo. I initially thanked Lisa and her team for the work that they put in. We have had a very challenging time for the last several months since March. All of us have tackled it in various ways. David Stumbo has been the president of the Solicitors Association, and he has kept us together. We've met every week. We've talked about how we're going to go about getting trials ready to go. He's done an outstanding job keeping all of us moving and keeping all of us in touch, making sure that we all know what the next steps are coming. He and his team have already tried a case. I know Jimmy Richardson out in Horry County, they've already tried some cases. So we're clearly getting back in the game, and David is somebody that really needs to be thanked for all the work that he's put in as president of our association. So David, thank you so much for what you've done. I again congratulate all of you people out there who are a group of small groups of citizens who change this world. Thank you for all that you do. David, I'll turn it over to you.